All right, let's turn that off. All right, what up, you guys? It is your girl, Ayana, aka the Crafty Notary. We are here back with another book club meeting. We're a little bit before 7 o'clock, and I did that on purpose so that I can kind of like shoot the breeze and let folks come in and talk to you all. Um, I just want to let you know that we are on chapter 12, and the book is called The How To Guide, the Complete How To Guide for Notaries. I'm going to stream it on the bottom so that you can see what's going on. And we are through this chapter, will end the chapter of the Notarial Acts. Chapter 13 will start the special circumstances. And then we just have a few more sessions left. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Oh, that's 3 months. Uh, yeah, that's 12 weeks. So nah, we're gonna have to double up on some of these. So we might double up tonight so that we can get through some of these. So we can get through with this book. So I have to move on and uh, create a general notary class. It has been requested, so I need to do that. And so I wanted to do that once we got through the book, or once we got a good ways through the book. So um, we will be through the notarial acts today, and hopefully let's just hopefully we can just keep it going and get through chapter 13 as well. Let me click on it so I can see how many pages it is. It's 10. Chapter tonight is 7 pages, so we may be able to get through both of those tonight. I would very much like to do that. So, um, welcome to the book club. For those of you that are watching the replay and are new, um, I am a notary public for the state of Florida. I am also a Ron. I am also a loan signing agent. So I am all three. And the only thing that I don't really care to do is weddings at this point. However, I will do quick elopements, just not more formal weddings. It's not something that I am currently interested in doing, but I will do, just a 1-2 elopement or whatever have you. Um, we will wait for 2 more minutes, and then we will get started because this is being recorded. So we will watch, whomever joins will watch the replay, and you will be able to fast forward through this introduction. It's going to be probably about 7 or 8 minutes. So if you go around the 8 minute mark, you will see the book club starting. All right. All right. So please feel free to chat. Please also feel free to do the add reactions or add um, super chats. All of that is available to you. It is not required, but what is required is that you like this video. So if you exit out of the live stream, not of the live stream, out of the chat, you can go back and like this video. So for everyone that is currently watching the video now, I think there's only one. Make sure you please like the video, and we will get started. All right. let's get started. I'm going to make this full screen so that and let me turn off the ticker so that we can get going. All right. So, chapter 12 is all about protests, dispositions, and other acts. And I think these are probably lesser known types of notarial acts. So, I'm kind of interested to get into what these types of notarial acts entail and whether or not they are permissible in the state of Florida. I don't have my primer today. It is in another room, ironically or unfortunately. So we will just have to lean with it, rock with it today as far as verifying information for Florida. So this one starts with in the preceding 4 chapters, we detail the procedures and requirements for the most often executed notarizations, acknowledgments, jurats with oaths and affirmations, copy certifications, and proof of execution. Now we'll touch upon some of the less common notarial acts, including the execution of protests and taking dispositions. So it says, once common, protests are rarely performed today. So a protest is a written statement by a notary or another authorized officer indicating that payment for a negotiable instrument, such as a check or a promissory note, has not been received. Failure to pay on a negotiable instrument is called dishonor. All right. In the 19th century, protests were common notarial acts. I think that's funny that it says in the 19th century, um, which doesn't seem that long ago, right? What are we in now? The 20th or 21st century? I don't know where we are. But in the 19th century, protests were common notarial acts, but they are rarely performed today due to the advent of modern electronic communication, resulting in changes in the banking and financial system. Antiquated statutes still give notaries the power to execute protests in most states. Notary acts of protest are complicated and varied. They require special knowledge of financial and legal terms. Only a notary who has special knowledge or who is under the supervision of an experienced bank officer or attorney should execute a protest. I don't think protests are something that is allowed in Florida. I did not see that under our approved notarial acts. All right. Deposition. So it says only court trained reporters should take depositions. Any notary, however, may swear in the deponent and execute the jurat in conjunction with the deposition. So, a deposition is a signed transcript of a person's oral statements taken down, usually by a court reporter for use in a lawsuit. The individual who gives a deposition is called a deponent. Notaries have the power to take depositions in most states, but it is usually trained shorthand or court reporters, most of who are also notaries, that take depositions. Strict rules of procedure dictate how depositions are executed, so notaries without appropriate training or supervision should not attempt them. Okay, so this is not something that we just go out and say we do. You should be trained. It says instead, the notary should refer to the request to a court reporter. Okay. In executing a deposition, the deponent is first sworn to tell the truth, then asked a series of questions by attorneys. The deponent's answers are taken down and later transcribed in type form. The deponent then signs the typed deposition before an official witness. Normally, the same court reporter, notary, swears in the deponent beforehand, writes down the testimony, and later witnesses the deponent's signing of the typed deposition. However, in some situations, a notary may be asked only to swear in a deponent and witness the signing of a deposition that is taken by a court reporter who is not a notary. This is often the case when a court reporter travels from another state to take the deposition. Being from another state, the court reporter would not have notarial jurisdiction to swear in the deponent or officially witness the signature. In these circumstances, the local notary merely administers an oath or affirmation, then executes a jurat, so no special skill would be required. The term deposition is often used interchangeably with affidavit, but there are major technical differences. A deposition is associated with a lawsuit or trial, unlike an affidavit, which need not be, and requires that either side in the litigation be permitted to cross examine the deponent with questions and responses included in the deposition's text. Notaries will encounter previously prepared documents containing the term depose, which means in this context, testify under oath or affirmation. Such documents cannot precisely be described as depositions because the notary has not sworn in the signer beforehand and written down the spoken testimony. They are more properly termed affidavits and may be executed by notaries without any special expertise. So, this whole thing is just letting us know that there are special circumstances where a notary would notarize the written deposition text on behalf of the court reporter who may not have jurisdiction in that state where they have traveled to. And be sure that you're not confused by the word depose. If you should see it on a document, it does not automatically mean that that document is a deposition. It could just mean that that document, that person needs to testify under oath or affirmation. Um, and it's more so an affidavit versus a deposition. Okay. So for more, context, or if you didn't get that, I would implore you to read again. But the bottom line of that is that we generally do not perform notarial acts in deposition situations. So the oath or affirmation for a deposition would be, do you solemnly swear that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? We've all heard that one. And then they also have, do you solemnly affirm that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth? So both of those, we've heard those before. All right. Now, in Maine, South Carolina, Florida, and Nevada, notaries have the authority to perform marriages. In all other states, the notary public may not perform marriages unless the notary is also a member of the clergy. Each of the four states has varying customs and legal procedures for performing the marriage, as well as for completing and filing the marriage certificate and charging a fee. There is one common procedure in all instances. The couple getting married must obtain their marriage license and present it to the notary at the time of the ceremony. An in depth explanation of solemnizing nuptials is beyond the scope of this course. Before attempting to perform a marriage, the notary should check with the state and county officials for specific procedures. So I can speak to the procedure in the state of Florida so everyone knows that we are allowed to solemnize marriages. The maximum fee that we can charge for a marriage is $30. Okay. The couple will have to have gotten their marriage license from the clerk of courts prior to being married. If they are Florida residents, they must wait 3 days before they can get married. And the clerk of courts people will tell them that they have to wait 3 days. After that 3 day period, they are free to have the ceremony. If they are not residents of the state of Florida, they can get married the same day. And again, the clerk of courts will let them know when it is permissible for them to get married. However, that is a question that you need to ask when you get a phone call or an email or a text message about performing a wedding or notarizing a marriage license. You need to find out, do they have a valid marriage license? And if they're Florida residents, and if so, have they waited the 3-day period before they, before they can get married? So if not, then you can just schedule the day for the 3 days out or whatever have you. I also wanted to mention that you can also become a member of the clergy. There is a website that is ulc.org, universallifechurch.org, where you can easily, like within 5 minutes, sign up to be an ordained minister, where you can then conduct marriages in all 50 states. Now, you will have to check with the clerk of courts in any other state to ensure that the ordination is accepted, because in some cases it may not be accepted if it's um, because this is kind of a public type of church, if you will. However, let me put my face on the screen so you can see me. However, um, oh, I'm on the wrong screen. Here we go. However, um, it is an option. And when you are signing the marriage certificate or the marriage license as an ordained minister, you are not held to having to sign with you're not held to the $30 max. Hi, Rachel. I didn't have the chat open. Um, you are not held to that. You can charge um, whatever price that you would like to charge. And in addition to the $30 as a notary, you can also charge for other things that are outside of notarizing the actual marriage license. So you can still charge for travel. You can still charge for your time. You can charge for, rental of equipment, or coordination of the ceremony. There's a lot of things that you can charge for when you are in the wedding space. And I think I'm going to do a live with Brother Reggie, who's our moderator, to have him talk about the marriage, the wedding business. So stay tuned for that. I think we're going to do that. I don't know if I want to wait until after the book club is over or before. Probably not. We'll probably just do it while all this is going on. All right. So moving on, we're going to talk about Louisiana notary laws. Louisiana notaries have vastly different powers than in the 49 other states and the District of Columbia. This is due to Louisiana's French heritage. Like notaries in France and the Latin nations, Louisiana notaries have the authority not only to witness the signing and acknowledging of documents, but also to draft and prepare many documents. They carry out many of the functions that attorneys perform throughout the rest of the United States. Louisiana notaries are highly trained professionals who are attorneys in most cases. Aside from certain witnessing powers that they share with other U.S. notaries, their duties in drafting and preparing documents are, of course, beyond the scope of this course. All right. And then a few additional powers. So, a few states give other powers to notaries. Some of these powers are antiquated and rarely used, others are commonly performed. So we got in Pennsylvania, notaries may qualify to have certain ministerial functions in processing paperwork for the registration and conveyance of motor vehicles. That's interesting. Florida notaries are authorized to verify vehicle identification numbers on applications for used motor vehicle titles, which is true. In addition, we may also certify the contents of a safe deposit box when opened by a financial institution when the rental payment is overdue and the renter cannot be located after several attempts. This is why it's important to market to banks, because we can be used. And oftentimes, even though they have notaries in the bank, they cannot use their own notary because it is a conflict of interest. Notaries in Washington may certify that an event has occurred or an act has been performed. Such certification is based on either the notary's personal knowledge or on an oath and affirmation of a credible witness. Hold on. All right. In Texas, they allow in very limited situations a proof of acknowledgement by handwriting, whereby two witnesses well acquainted with the handwriting of an unavailable principal signer swear or affirm in writing that the signature of the principal is genuine. And many other states have similar distinctive acts that may be performed by a notary. Notaries in every state should read and understand their respective state's notary handbook and statutes in order to fully understand the scopes of their duties. Um, hey, Reggie. So, your notary handbook can be found on your state website. And for the state of Florida, that would be either florida.gov or sunbiz.org. That's where you would find the handbook for uh, all of the notary statutes and everything. So that brings us to the end of this particular chapter. I'm going to skip the quiz because this is kind of a lesser known acts of things, and we'll move right into chapter 13 so that like I said, we can start knocking out some of this book and get on with it. All right, so let me pause. There are now 4 people watching, and I would love it very much if you could click that like button. You would just click out of the chat and click the like button, and your girl would be happy after that. All right. So, next, we're going to talk about foreign language signers and documents. All right. Foreign languages create special concerns for notaries. Signers who do not speak a common language with the notary and documents written in languages the notary does not understand make performing a notary act difficult and sometimes impossible. State laws provide the notary with little guidance for dealing with foreign speaking signers and foreign language documents. Laws may specify that only persons who can read and write the English language may be commissioned as notaries, or they may stipulate that only English language documents may be accepted by a recorder. However, no law specifically prohibits a notary from serving a foreign speaking signer or from notarizing a foreign language document. In fact, it may be considered discriminatory to refuse a lawful request for a notarization simply because the signer speaks or the document is written in a foreign language. So I bet many of us probably did not know that. Sometimes we assume we don't speak Spanish, therefore we cannot serve you. All right. With foreign speaking signers, the issue is not the language spoken, but the communication. Direct communication between the signer and the notary is essential in acknowledging a signature, reciting an oath or affirmation, or responding to a notary's questions about identity. In addition, ascertaining willingness and awareness is all but impossible without direct communication. So, it is vital that the notary and signer communicate in a common language, whether English, Spanish, French, Japanese, Arabic, sign language, or any other language. The notary should never rely on an intermediary or interpreter in performing a notary act. The communication must be direct. A rare exception to this rule is Arizona, where interpreters are allowed under certain specific conditions. Besides the possibility of misunderstanding, the interpreter may have a motive for misrepresenting the facts. For example, a dishonest interpreter might tell a signer who cannot understand English that an English language document is a life insurance policy when it's actually a quitclaim deed transferring the signer's property to the interpreter. If the notary and signer cannot effectively communicate in the same language, the notary must refuse to perform the notarization. The signer may be referred through an interpreter by other means, um, or by other means to a notary who speaks the given language. Sometimes foreign consulates, which normally have officers with notary powers on staff, may be a convenient solution for the foreign speaking signer. So it's not the fact that they speak a foreign language that we can't notarize them, it's the fact that we can't communicate with them. So if by chance we speak another language, we absolutely can notarize that document as long as we can communicate effectively in the language that they know and understand. There has been instances where I've had Spanish speaking signers and they know just enough English to understand what I am saying to them, or asking them. And I ask the questions directly to them and not to family members who may be trying to interpret what I'm saying to them. Right. So, for foreign language documents, normally there's no problem notarizing a foreign language document provided the notary can read and write the language in which it is written, and the requested act may legally be performed by a notary in the particular state. If the notary understands the foreign language, he or she performs the act like any other, ensuring that the foreign language certificate wording is equivalent to the wording required for the notary's jurisdiction. The notary should note the document's language in the additional information area of their journal. The difficulties occur when documents are prepared in a language that a notary does not understand. So, if you are a notary and you cannot read or write the language of a document, you may not recognize an unauthorized notary act, or you may not understand how to proceed with the notarization. In addition, gleaning for data for the journal entry, hold on, and completing a certificate correctly may be a problem, and blatant frauds can go undetected. So, how do we proceed? With documents the notary cannot read, there very well may be a problem knowing how to proceed. Usually, it is a notary certificate that instructs the notary what act to perform. However, if the certificate is in a language you cannot understand, you will have no instructions on whether to perform an acknowledgement or a jurat or some other act. In addition, the notary of a particular state might be prohibited from notarizing certain documents or may be required to follow specific procedures with certain types of documents. If the notary cannot understand the document type, he or she may perform an improper act, which or may perform the notarization incorrectly. So, for example, California notaries must obtain thumbprints in their journals for all signers of deeds they notarize. But if the notary doesn't know the document is a deed, then you won't know to get a thumbprint, right? All right. So, you need to be able to glean accurate data for your journal. So if a notary can't read the document, you might not be able to extract accurate data to record in the official notary journal. Such vital data as the type or title of the document may not be understandable. Dates can pose a problem. For example, 5/12/08 means May 12, 2017 in some parts of the world, and December 5th, 2017 in others. A notary's reliance on the signer to interpret the document, on a third party interpreter, or even a written translation can present its own hazards. So, completing the certificate correctly. If you can't read the certificate, you might fail to comply with the instructions on where to place the seal, what types of ID is acceptable, and other important matters. This might possibly cause invalidation of the document. Such failure to comply is more likely when the notary's certificate is in a language unknown to the notary and contains blank spaces for the notary to complete. Some states require the notarial certificate to be in English. In those states, notaries are prohibited from completing foreign language certificates, even if they understand the language in which the certificate is written. And so, since I don't have my primer, I can't validate whether or not these are accepted in the state of Florida, but I do know you can have documents interpreted by an interpreter, and then you can notarize the interpreter's signature that the document is true and correct. All right. Or an acknowledgement, or I think it's probably a jurat, but I know that you can do that. All right. Notaries are not required to read the documents that they notarize, but in extracting data for their journal and in completing certificates, we sometimes cannot help but notice that a document is fraudulent. Such would be the case with a document that makes clearly impossible promises about goods and services. The notary cannot detect blatant frauds when the document is in a language that the notary can't read. And any lawsuit resulting from a notarized fraudulent document might require the notary to prove he or she was not involved in a conspiracy to defraud. So that's another reason. At the end of the day, I think that, let me show my face. At the end of the day, I think that at all costs, you want to protect your commission. And um, if there's ever any doubt, any ounce of doubt, any iota of doubt on whether or not something may or may not be legal or acceptable, I would say defer to refusing the notarization. More than likely, they'll go somewhere else, and more than likely, they will find someone who feels either comfortable enough or stupid enough to complete the notarization. But you have to always think about it from the standpoint of protecting yourself. And for documents that are just not in your language, it's not worth the money to notarize something improperly and then be called to the mat later on down the line. It's not worth it. All right, let's keep going. Oh, I gotta get over here. Here we go. So, another consideration is when notaries are asked to notarize not just foreign language documents, but also any document that will be sent to a non English speaking person. There is a likelihood that in the US, the notary's function will be misunderstood. Since notaries in some other countries can draft documents and validate their facts, foreign born document recipients may mistakenly believe that US notaries can do the same. For example, US notary seals on affidavits of citizenship in which signers state that they are US citizens may be misunderstood in Latin nations as official proof of that claimed citizenship. Another example of that is in the country of Mexico, the notarios are also the people who kind of act as the attorney in real estate transactions. And so when you're doing real estate work over in the country of Mexico, you need to look for a notario in order to close the deal. And so it could be misconstrued that we have that same function here by someone from that country. And so that is why it is important to be able to understand what the documents are saying so that you know whether or not you're performing a legal act. So, signers who want foreign documents notarized may have alternatives other than going to a notary who cannot read and write the language. Foreign consulates, bilingual notaries, and English translations. So, many countries have consulates in certain major US cities, and one of the functions of these offices is to notarize documents that are bound for the particular consulate's home nation. Most of the larger foreign consulates in the United States will have officials with notary powers. However, it may not be practical for a signer to travel to the city where a consulate is located. All right. Number two, often notaries who speak English and a second language can be located to notarize documents in um, written in the second language. In certain ethnic sections of large cities, it is not difficult to find such notaries. So, here in Florida, many people are also from Latino countries, and a lot of people are bilingual either in Latino or Caribbean country. And so a lot of people in the state of Florida may be fluent in another language, whether it be Creole, like Haitian Creole, or French or Spanish, most commonly. Portuguese is another one. It may not be hard to find someone who speaks those languages. All right. So, if acceptable to the document's recipients, notaries may notarize signed English language translations of a document they cannot read. Sometimes on standard forms, English translations are provided along with the foreign writing. All right. So, let's look at this. In no U.S. state is a bilingual notary allowed to use a notary seal to certify the accuracy of a translation. However, a notary may notarize a signature on a translator's declaration, which is an affidavit, perhaps an affidavit, stating that the translation is accurate. Notaries, of course, cannot notarize their own signatures on translators' declarations. So, if you translated a document, you can't notarize your own signature, and we cannot certify to the accuracy of the translation. We can notarize the signature of the translator declaring that it is an accurate translation. And that is most commonly probably the case. That's most often will be the case if you are not bilingual and cannot read or write in another language. All right, let's talk about non-Roman letter signatures. So it says the notary may encounter a situation in which an individual wishes to sign using characters other than the Roman alphabet used in English. For example, the signer may prefer to sign with Japanese, Chinese, Arabic, Hebrew, or Cyrillic alphabetic characters. Whether such signatures are on documents written in English or a foreign language, notaries should not notarize any signatures written in characters they cannot read, since the sign names could be different from the ones they are told. Moreover, some public recorders will refuse a document or to record a document bearing such signatures unless a translator's declaration is attached or special procedures were used. It's good policy to have signers check with the recorder first before notarizing a signature in non-Roman characters on a recorded document. So that is the end of chapter 13. I think I'm going to skip the quiz on this one too, because I don't know, folks aren't really active. So let's just keep going. I'm going to go to chapter 14. Since we're only 30 minutes in, we will knock out another chapter. All right, and this is a good one. Notarizing for minors. This is a good one, right? So, legal age. In general, persons must reach the age of majority. In the United States, that is 18, but it could be 18 to 21, depending on the state law, in order to exercise all normal legal rights. Those under the legal age are called minors and are not considered legally competent to handle their own legal affairs, to sign documents, contracts, or deeds, or to conduct business for themselves. To put this in perspective with the preceding chapter, minors have a legal disability that disqualifies them from signing documents for themselves. Normally, it's parents or court appointed guardians who must sign on a minor's behalf. But in rare instances, minors may lawfully sign documents and have their signatures notarized. Such circumstances would include minors approved by a court as reliable witness and emancipated minors engaged in business who can also sign contracts. An emancipated minor is an adolescent freed from the control and responsibility of his or her parents. It must be nice, right, Reggie? I do believe that my notary friend Bergeau asked the Secretary of State or asked the Division of Notary at the state whether or not we could notarize minors' signatures. And she sent me that email, and I don't know. Let me see if I can find it really quickly. Hold on. I'm going to look for it right now because it is interesting what the state of Florida did say. But I have to figure out where did I save it? Because I did have it, but I have to figure out where I saved it. I did save it somewhere, but I just don't know where I saved it. Oh well, we will have to move on. We will have to move on. So let me get my book back up here somewhere. Where did it go? Here it is. All right. Yep. I'll have to look. I'll have to ask her for that or look for it, and then I will present that at another time. But I know she did ask for state of Florida because it's not in our primer. All right. So some concerns you should have. We should be particularly aware of the problems presented by younger signers. A notary should not necessarily refuse to notarize for a minor if the youth presents adequate identification and appears aware and willing to sign, and can satisfy the notary's inquiry about having the authority to sign. So, the biggest problem with minors is determining their identity, because often they don't have state issued ID. A notary identifies a minor in the same methods as an adult, either personal knowledge, credible identifying witnesses, or ID documents. And since a minor may not be old enough to obtain a driver's license and may not possess any other type of ID, such as a passport, identification must usually be based on the notary's own personal knowledge of the minor's identity or on credible identifying witnesses who can vouch for the identity of the signer. Because credible identifying witnesses should be impartial and unaffected by the document, parents and relatives should not be used to identify their own children or family members. Impartial means that the credible identifying witness should neither have a financial interest in the document nor be named in or affected by it. Usually, a parent will have direct interest in any document that their child signs. So, credible identifying witnesses is out unless you get two neighbors to identify the minor. But minor children can get a state identification card, and they also can get passports, because my bonus children has had a state identification card for the longest time, for a very long time. And I believe that their mother got the card for them to so that there was no issues when they went on cruise ships. So that it is possible for them to have ID. Now, determining willingness and awareness for a minor is done the same way you do an adult. To determine a minor's willingness to sign, the notary should simply ask the minor if he or she has signed or is about to sign the document voluntarily, and then observe the minor's demeanor. In some situations, Asking an influential third party, such as a parent, to leave the room may assist the notary in determining the signer's willingness. If the notary suspects that the minor is being forced to sign, we should refuse the notarization. So, if the parent's not willing to leave the room and you feel that the child is being coerced or forced to sign, you can absolutely ask them to leave the room. And if they don't want to, then you may know that may lead to, knowing there's something fishy and you can refuse the notarization. The test for awareness, if you remember, is just to engage in a conversation about the document. If the minor can communicate coherently with the notary may consider the signer aware and comprehending. However, if the signer is unable to respond intelligibly to a notary's basic questions, the notary should refuse to notarize. Experts, such as the minor's attorney, may also be consulted to determine awareness. If an expert says the minor signer is aware, the notary can usually proceed, recording the expert's remark in the journal. All right. The notary should also make reasonable effort to determine that the minor does have the authority to sign the document presented for the notarization. This can be accomplished by asking the minor, as well as any adult present, what agency or person directed the minor to sign. It also may be prudent and useful to ask if the agency or person accepting the document is aware that the signer is not of legal age, and if the person or agency will accept a minor's signature. And the NNA recommends to alert documents recipient to the signer's age. It's a good idea to require the signers to write their age after their signature. A notary is not required to verify the minor's signer's age. All right. So that's the end of this chapter. This was a quick one too. I will say here, and I'm going to stop here for the evening. But I keep clicking on the wrong screen. What I will say is that when you are notarizing a minor and determining, oh no, that's not what I wanted to say. What I wanted to say was when you are determining awareness and willingness to sign, it's not that they have to know what the document says or what the document does. Typically, they do know and they should know. However, a lot of times in the case of the elderly, you can explain it and they may forget just that quickly. But you still want to be sure to assess whether or not they are aware by talking to them and willing to sign by asking them if they are willing to sign that document. If they start going off like they don't know what it is, and just like a child, if they don't know what it is and I'm not sure, then you can refuse to sign the document. And I probably would refuse to notarize the document. So that is going to do it for today. We covered 3 chapters, which I'm actually pretty happy about, because like I said, I want to get through this book at some point. And what did I do with the I just lost the, oh geez. Okay. Well, I lost my I think I closed my tab there. I was trying to see what the next chapter was. So let me log back into the NNA. In the meantime, if anyone has any questions, feel free to ask them now. This is the book that we are reading. This book can be purchased from the the National Notary Association. You can also, if you are a member of the NNA, you can also read along with an electronic copy of the book by going to your member benefits under my NNA. So we went through, so the next chapter would be, oh, I think I skipped one. I think I skipped the disabled signers. I did. Oh no. So I skipped chapter 14 and went to chapter 15. So we will have to double back with chapter 14 um, on the next one. And yes, that's a good one because it talks about signature by mark and all that stuff. So we'll double back on chapter 14 on the next one. So this will be a little bit out of order. No, you know what? Should I just do it? Skipping what? Yeah, I skipped that by accident. I skipped it by accident. So you know what? Let's just do it because I don't want the video to be out of sync. So let's just do it. Let's go back. So let's go back. Chapter 14. We did chapters what do we do today? And I had it open too the whole time. So we did chapters 12, 13, and 15 so far. So we're going to go back to chapter 14 and talk about meeting the needs of disabled signers because this is actually good information because this one is one that you will frequently come about if you're work doing like nursing homes and general notary work in general. All right, so document signers with certain physical or learning legal disabilities sometimes require special attentions from notaries. Let me blow this up a little bit more. Nope, not that far. That require special attention from notaries. So some disabilities, such as those that physically prohibit a person from signing or impair an individual's understanding, may make notarization impossible. Others simply may require a notary to apply special procedures. Generally speaking, there's three kinds of disability that might affect a person's ability to sign a document and perform other actions for necessary for notarization. Those three things are physical disability, intellectual disability, and legal disability. All right. So, physical disability is one that prohibits or inhibits writing. So, that's paralysis, broken hand, or impairs communication, as with seeing or hearing or speech impaired signers. That's physical disability. An intellectual disability results from either illiteracy or a low IQ that can make signing or understanding a document difficult. A legal disability includes a minor, youthful age, or proven insanity, which can restrict or disqualify persons from signing on their own behalf. In all but a few states, notaries may not perform notarizations for persons who are prevented by physical weakness or illiteracy from writing a signature or at least making a mark, such as an X or a thumbprint. If a signer cannot write a signature but can make an X or leave a thumbprint, the procedure is called signature by mark. This is legal in the state of Florida. All right. And the document can be notarized. In cases where a signer cannot even make a mark, some other arrangements may have to be made, where generally the guardian or the conservator will be appointed by a court to handle their affairs or act on their own behalf, on the person's behalf. The notary does not have the authority to personally authorize or direct a disabled person to sign with a pen held in their mouth or to employ any other extraordinary procedures. Only the person's attorney or another individual officially appointed to look after the person's legal affairs can sanction those types of procedures. There is absolutely no circumstances where notaries may allow another person to guide an individual's hand to sign a document. The signer may receive no assistance in making the signature. All right. In a few states, notaries have the authority to sign the name of the person who is unable to sign or make a mark. The disabled person must be competent, must personally appear before the notary, and must orally direct the notary or third party in the presence of the notary to sign by proxy. In some states, a certain disability signed by the disabled person's physician must also accompany the document. This procedure helps disabled signers better handle their affairs. I cannot validate whether or not that is legal or not in Florida. I am going to refer you to either the state laws or the notary primer. All right. So, when a signer, due to illiteracy or physical disability, cannot write a signature, he or she may sign by mark. However, if the signer can produce a legible signature, even if it's abnormal, such a signature is preferred and the signature by mark is not necessary. The customary mark is an X, but other marks, such as a thumbprint, also may be acceptable. In some instances may require witnesses in addition to the notary to the making of the mark. Typically, the witnesses sign the document and one witness prints the marker's name besides the mark on the document. Each witness should have no financial or beneficial interest in the document and actually must see the principal or marker make the mark on the document. An ideal witness must demonstrate honesty, awareness, and impartiality. Generally, state laws allow a signer's relative to serve as a witness, but if the relative stands to gain or lose from the transaction, this person would not be an ideal witness. The notary need not personally know the witnesses, nor is it necessary for the witnesses to personally know the signer by mark, but in both cases, there should be satisfactory evidence of identity. The signature by mark witnesses sign the document near the principal's mark, and one witness also prints the signer's name next to the mark. Sometimes the words his or her mark are also included. The same procedure is followed for the journal signature. The principal signs with a mark. The witnesses also sign, and one witness writes the marker's name near the mark. So an example of this is below. So you have the X, which is the mark made by Karen A. Schulman, which one of the witnesses printed this, and then they both signed their name next to the mark and included witness there, stating that they witnessed Karen A. Schulman make her mark. Okay. So, though some states allow the notary to serve as a witness to signature by mark, the NNA strongly recommends that the notary not be used as one of the witnesses. This prevents confusion about the notary's role. And I also would make another suggestion here in addition to the signature by mark. I personally do not like to be the second witness on estate planning documents such as wills, advanced healthcare directives, and power of attorneys. And it is for the same reason. It will prevent confusion about my role in the transaction as the notary. And so, even though I know in the state of Florida we are allowed to witness or be a witness for those documents, I, Ayana, NC Lugo, aka the crafty notary, prefers not to be the second witness, and I would try to find a second witness before I become the witness on those documents, just to prevent confusion about the role. And those are things that you need to think about when we're working in this business. All right, so the signature by marks witnesses' addresses should be recorded in the additional information column of the journal if the space allows. Otherwise, additional journal lines can be used to accommodate that information. This procedure does not require any special acknowledgement certificate. Many notaries, though, prefer to use a special purpose signature by mark form that state the names and addresses of the witnesses who signed the document. A typical signature by mark acknowledgement follows this format. So you have your venue, the statement of particulars here, and then notary signature, first witness name and address, second witness name and address. All right. So if you know ahead of time that you will be doing a signature by mark, you can definitely get this certificate ready for your signing. Now, for impaired communication, just like foreign signers, if the signer cannot communicate directly with the notary due to a hearing, speech, or sight impairment, the notary cannot perform a notary act for that person. Communication between the signer and the notary may be achieved through written notes, lip reading, sign language, or other means, but it must be direct. A third party may not serve as an interpreter. So if you don't understand sign language, but the person can write, then they can write notes to you. If they're reading your lips and they can write to you, whichever way that you can communicate directly, you can do so without a third party. When with a blind signer, the notary should proceed carefully because there exists a potential for fraud. A sightless person may have been misled about the contents of a document he or she cannot see or read. The notary must determine whether the documents presented by the blind persons are the ones they intend to sign. One way of doing this is to offer to read, but not explain, some or all of the document to the signer. Hearing and speech impaired document signers must communicate their willingness and awareness sufficiently to the notary, and in the case of jurat, indicate compliance with the oath or affirmation. Many hearing impaired signers read lips and speak clearly or communicate through written notes. A personal computer may prove helpful to the notary in communication with a hearing or speech impaired signer and can even be used to administer required oaths. Through limited speech, lip reading, written notes, gestures, or any combination of these, most hearing and speech impaired signers are able to communicate with another person. If a notary happens to be conversant in sign language, this will help. Once the notary establishes the signer's understanding and awareness, and any special accommodations are noted in the journal, notarizations for the seeing, hearing, and speech impaired may be performed using regular notarial certificates. All right. Awareness. While the disabled signer may have certain physical, intellectual limitations, simply having a disability does not mean that the signer is uncomprehending. A disability does not mean a person cannot handle his or her personal affairs, sign documents, and have a signature notarized. Disabled persons have legal rights as well as the legitimate need to execute legal documents like any other person. However, some intellectual and legal disabilities may be associated with lack of comprehension. So, certain mental conditions that are inborn or caused by an accident or illness may deprive an individual of the judgment needed to handle his or her own legal affairs in a responsible manner. Such persons may be in custody of an institution or a guardian who has court given powers to act on behalf of the mentally dysfunctional person. Signers who possess what is termed a legal disability are considered incompetent due to disqualifications imposed by law. Minors, which we already talked about, and those proven in court to be insane are considered legally disabled and are restricted or disqualified from signing for themselves. Being below the legal age is by far the most common cause of legal incompetence and is the subject of the following chapter, which we already talked about. All right. So, determining the awareness of a disabled signer is done the same way you do for any other signer. In chapter 5, we learn the best tactic when confronted with any individual of a questionable mental ability is to engage that person in simple conversation. It then should become apparent whether the person is capable of understanding what's happening and is a willing party to the transaction. Experts, such as the signer's physician or attorney, may also be consulted to determine awareness. If such an expert indicates a signer is comprehending, the notary can proceed. The expert's remarks should be recorded in the notary journal. However, the notary always has the final determination whether to proceed with a notarization. If comments of a physician or attorney about the signer's awareness is at odds with what the notary's personal observation and common sense is, the notary must not proceed. So whether they're telling you that person is competent and you're visually looking at them and your common sense is telling you that they're not, you must not proceed. All right. And that is the end of the disability chapter. So we covered it. So hello to Lady Sanger Jones, LPN. Hi, how are you? Thanks for stopping by. So we have now covered chapters. Let me get back there. 12, 13, 14, and 15. So now we're on to 16, 17, 18, 19, 20, 21, 22, 23, 24. So hopefully in the next one, maybe we can do another 3 or 4, and that way we can get through with this book. Because from this point on out, we're just talking about troublesome documents and then pitfalls and then professional responsibility. So those are things that are not that we should know but is not pertinent to the act of notarization. So that is where we will stop for today. As usual, thank you very much for attending the live book club. I am here every Thursday at 7 p.m. Today was a little early just so I could kind of chop it up, but at 7 p.m. is when I am here. Feel free to comment below this video if you're watching the replay, #replay. Comment. I answer all comments on my YouTube channel. Also, if you are new here, subscribe to the channel. I welcome you to the family. Subscribe. I have regular content that is here. If you hit the notification bell, you will be notified when that content is uploaded. And one last thing, and this one's a really, really easy one. Before you go, hit that like button and let YouTube know that you enjoyed this video so that it is shown to more people in the algorithm. Okay? So that's all I got for today. I am going to go have dinner now. So thank you so much for watching, and I will catch you guys on the next video. Peace out.